All rise. The Honorables, the presiding judge, and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon and welcome to the North Carolina Court of Appeals. Your panel this afternoon consists of, to my right, Judge Jeff Carpenter. To my left, Judge Julie Flood. I'm John Tyson. I'd like to recognize our clerk, Delana McKessie, for opening court, and also our court's marshal, Officer Richard Remilliard. We have one case on the docket today for arguments. Are there any preliminary matters to come before the court before we start?
No, not pressure.
Okay. All right, then we have the case of Onnipauper LLC versus Eugene Dunston. We will hear from the appellant.
Good afternoon, and may it please the court. My name is Hunter Winstead, and I represent the plaintiff appellant landlord in this matter. My intention is to reserve 5 minutes for rebuttal.
Okay.
This case is about a landlord and a tenant who mutually agreed to the following lease term. The landlord would provide well water to the tenant, and in exchange, the tenant would pay a flat monthly fee in advance on the first of each month. For 2.5 years, both parties upheld their end of the deal. The landlord provided the well water, and the tenant voluntarily and willingly paid. However, only after the landlord terminated the tenant's month-to-month lease, and after the tenant refused to vacate the premises, did the tenant develop the idea that those 29 well water payments he had previously voluntarily made were somehow unlawful. Thus, the tenant initiated the present counterclaim. Then, in an unprecedented and unsupported decision, the trial court determined that the landlord violated 2 very narrow provisions of the North Carolina Debt Collections Act. One for each of those 29 well water payments that the landlord simply passively accepted, and one for merely alleging on the small claims complaint that the tenant's rate of rent was $1,350. Now, under this court's de novo review, it becomes clear that the trial court's order contains numerous errors of law and is neither supported by its own findings of fact or the record evidence. Therefore, this court should reverse. Now, with respect to issue 1 before this court, subsection 75-55(2) of the North Carolina Debt Collections Act is a very narrow provision designed to prohibit debt collectors from charging exorbitant incidental fees. To prevail on a claim under this subsection, 6 elements must be shown. First, it must be shown that the alleged violator was engaging in the affirmative act of debt collection from a consumer. Second, it must be shown that that debt collector was attempting to collect or collecting fees incidental to that principal debt. Third, it must be shown that the debt collector was not legally entitled to accept those incidental fees. Fourth, it must be shown that in merely accepting those fees, the debt collector was engaging in an unfair or deceptive act that rises to the level of unconscionability. Fifth, the act must have been in or affecting commerce. And sixth, there must have been a proximate cause of an injury from the act.
Mr. Winstead, your client below was the plaintiff, correct?
That's right, Your Honor.
And this case came out of a summary ejectment complaint.
That's right, Your Honor.
I understand you had an expired lease month to month. You demanded possession. The tenant refused to leave, and you brought summary ejectment in order to regain possession of the premises.
That's
right. Correct?
That's exactly right.
And there were counterclaims asserted against your client, which the lower court denied your relief and granted relief to the tenant.
That's exactly right.
Did you regain possession?
Yes, eventually, only after a second trial was brought. An entirely separate summary ejectment proceeding was brought later, and now the landlord has regained possession.
So normally when and I understand this premises was served by well water, correct?
That's right.
And normally, the habitability statute under the Residential Rental Agreements Act, there's an obligation to provide what's referred to as a habitable premises. Is that correct?
That's right, Your Honor.
Under that act, is there any obligation for a landlord to provide water?
Not just by virtue of the act. It's a duty that arises only as a matter of contract. And that's what subsection 42-41 makes clear, that says the duties in 42-42 are dependent upon the payment of rent. So it's a matter of contract.
All right, and in this case, the utilities was not a part of the actual rent, or was it?
It was the tenant, under the base rent, it was the tenant's responsibility to pay for water, just as it would in a normal case where it would pay a public utility, for instance. Then there's a separate agreement for the well water, which is the $125 flat fee.
Okay, was the amount that the tenant was to pay, was it based on usage?
It was simply a flat fee that the representative of the landlord used that amount because it's what Section 8 uses in other properties that they manage. It's an allocation. It's not based on the usage per se. It's just a flat fee for the service of the well water.
And that came about as a result of an amendment to the original lease?
That's exactly right, on page 44 of the record, Your Honor.
And also, there was a provision regarding washer and dryer, separate fee for that?
That's right.
And that fee was remitted?
That's right, Your Honor, yes.
Was that remission in writing?
That I'm not sure, Your Honor. That issue is not necessarily relevant in this case. I don't believe there was a remittance in writing, but
Well, doesn't it go to the last issue that the amount that you billed on the last claim did include that $50 fee?
Oh, no, to issue 2, Your Honor, regarding 75-54-4. No, Your Honor, the $1,350 was the base rent. The rent had increased. At the time that the complaint was filed, the base rent was $1,350, and that's testimony from Yin Zhang on page 41 of the record.
Well, at the time, it was $1,175.
At the time that the contract, back in 2019, it was $1,175, yes.
And then another $125 for the water.
That's right.
So that's $1,300.
Yes, well, by the time the complaint was filed, though, the base rent had increased.
Okay.
So it was
So the
$1,470.
$50 was not for the washer and dryer fee, it was for added rent?
It was never charged. My understanding is that it just was never charged to the tenant.
Okay, thank you.
Yes, Your Honor. Now, 5 of the 6 necessary elements of the 75-55-2 claim have not been established in this case. First, in merely passively accepting the voluntary and timely well water payments, the landlord was not engaged in debt collection. Second, these well water payments clearly were not incidental fees. Third, even if they were incidental fees, and even if the NCDCA did broadly apply, there could not have been a violation because the landlord was legally entitled, pursuant to the itemized rent provision on page 44, to accept those payments. Fourth, there was no unfair act or deceptive act, and there was certainly no unconscionable act. And then fifth and finally, there was never any proximate cause of any injury. Now, with respect to element number 1, there could not have been a violation of the NCDCA because the NCDCA only governs the personal solicitation to recover defaulted payments. And Your Honors, this comes from the plain definitions of the statute. There's 3 definitions that control. There's debt collector, and consumer. Together, these definitions show that the NCDCA only governs the affirmative collection of an obligation that is either owed or due and has been incurred by a consumer. Now, these words incurred and collect are important here because their plain meanings show there must be the personal solicitation to recover defaulted payments. Now, this court has explained that the word incurred, it has this negative connotation of falling into debt. A debt is only incurred when liability attaches. So in a services contract like the present case, liability does not attach until there's been a default on the payment, especially where here the payments were made in advance of any use of water.
Now,
So
on your summary judgment, did you not allege past due rent of $1,350?
yes, but that had no relation to the 29 well water payments that had already been accepted. That had happened prior to any summary ejectment proceedings. They were paid voluntarily and timely.
But you did allege a sum due.
Yes, there was some due. I can't remember exactly what that was. I think it was only the rent for March I believe, Your Honor. I don't remember the exact amount, but yes, there was a portion of money owed, alleged.
And if I remember correctly, the rent here was being paid by a third party, is that correct?
That's right. Well, a portion of it was, there was a private agreement where the tenant was only paying, I believe, $198 directly. It was still liable for the entire amount, but there was the third party that was assisting the tenant to make those payments.
Is your client a party to that agreement?
Yes. And that agreement is not in the record, Your Honor. It's only the initial lease agreement that's dispositive in this case, and that's the agreement that's in the record. And that's really what only, pertaining to the counterclaims, that's the only agreement that really matters in this case.
Thank you.
So there must be, as we just briefly discussed, in order for a debt to be incurred, liability has to attach, which means a default. There also has to be an affirmative act. There has to be a collection. And as the United States Supreme Court has explained, there's only a collection when there is a personal solicitation or legal proceedings. That's just that affirmative act. And now, this interpretation makes sense when looking at the purpose behind why all of Article 2 really was enacted. So back in 1975, Attorney General Rufus Edmiston brought a claim against JCPenney because JCPenney and other similar companies were engaging in all sorts of unscrupulous debt collection practices. They would extend credit out to consumers, and then when that consumer could not make a payment, they defaulted on a payment, JCPenney had these collections agents who would call all of these debtors now at all hours of the day. They would call their employers. They would say that they were going to charge all sorts of exorbitant fees, all in an effort to collect those defaulted payments. Now, Attorney General Edmiston wanted to punish that activity. So he brought a claim in 1975 under what is now Article 1, because Article 2 didn't exist yet, 75-1.1. Now, the North Carolina Supreme Court denied that claim because it said at that time, 75-1.1 only applied to sales. It did not cover debt collection. So then only 2 weeks later, Attorney General Rufus Edmiston himself wrote what is now Article 2, the North Carolina Debt Collections Act. And then it was passed only about a month later in June of 1977, just after the Supreme Court of North Carolina had issued its decision. And thus, the intent behind Article 2 is to punish the exact activity that went unpunished in the JCPenney case. That is the personal solicitation to recover defaulted payments. This interpretation also makes sense in light of the precedents from this court. Since 1977, 45 years ago, neither of the appellate courts of this state have ever applied the North Carolina Debt Collections Act to any situation that did not involve the personal solicitation of defaulted payments. Now, the trial court in this case ignored the plain language that we just discussed, ignored the purpose behind the statute, and ignored this court's precedents. Instead, the trial court determined that the NCDCA just automatically applies by virtue of there being a household-related contract. Consider the example of the neighborhood teenager who wants to start his own lawn care business. So he goes to his neighbors and says, hey, I'll cut your grass once a week. In exchange, you pay me a flat monthly fee on the first of every month. Under the trial court's interpretation, that teenager just became a debt collector, subject to all the stringent terms of the NCDCA. For example, if that teenager knows that one of his neighbors has an attorney, the teenager is prevented under 75-55(3) from even speaking directly with one of those people that he's in contract with. That result is absurd. This court should reject the interpretation that the trial court adopted. Instead, it should adopt the plain meaning, the reasoning behind the statute, and its own precedents to conclude that there must be the personal solicitation of a defaulted payment in order for debt collection to occur.
If we agree with you that your client had the right to charge separately for the water, is the debt collection issue moot?
If this court agrees that the water fees were separate?
That you're, under Chapter 42, your client had the right to bill separately for the water. If we agree.
Oh, yes, but, Your Honor, I'm not sure that it would be moot. It would just, the claim would just fail because one of the necessary elements. So, in some sense, I guess it could be moot because the court would just say there was a legal entitlement. Because legal entitlement is a necessary element, then yes, the claim automatically fails. So these are 5 independent reasons for reversal. So yes, Your Honor, I think is the short answer to that question.
So let's go back to the contract claim. So under what basis, the trial court cited the Chapter 62, the Public Utility Statute, as a basis for metering, I think.
The trial court did not cite.
Well, it's argued. And
Yes,
it is argued.
Yes, that's right.
So can you walk us through that?
Sure. So there's really three theories to parse out here on the legal entitlement. Yeah, the first one is directly the 62-110G argument. That's the argument that was advanced at trial, and it clearly fails because the Public Utilities Act, which includes 62-110G, plainly does not apply where there is a water provision that does not supply more than 15 or more residential units. Here it's a single well that supplies only one residential house. So the Public Utilities Act clearly does not apply.
Okay, I want to clear up one thing,
Sure.
a factual dispute, or
Yes.
there was some argument that the well was separately metered, but that metering was not used. And my question is that meter for the power, for electricity to run the pump? Or was there an actual meter showing water usage on that well?
I don't actually know the answer to that question as to what the purpose was of the meter was. Possibly it was for the power, but I'm just not sure, Your Honor. But the point that really matters here is that there was no requirement that it needed to be metered. It just happened to be that there was a meter available for the well. I'm not exactly whether the meter was for water or for electricity, but it just was never used. And that's not in dispute.
Well, if it was power, it was certainly being used, because that would be the source of the power to run the pump.
Oh, yeah, that's right, Your Honor. That's right, yes. So that was the first argument, which was the tenant's argument at trial, was directly 62-110G. And then the trial court seemingly rejected that argument and adopted its own theory as to legal entitlement, which is the implied warranty of habitability theory. And that one just plainly fails, as we briefly discussed, because clearly under 42-42.1, the General Assembly has provided at least one example of how landlords can charge for water. So under the trial court's own interpretation, there would be a direct contradiction between 42-42.1, which is an explicit example of how landlords can provide water, and the trial court's seeming conclusion that landlords can never charge for water. So that's why that theory just fails on its face. Now, the third theory is the one advanced before this court for the first time on appeal, which is that subsection 42-42.1 somehow invalidates the itemized rent provision, which is on record page 44. Now, 42-42.1, however, says absolutely nothing about a private well water agreement. That statute only exists to incentivize those landlords who are purchasing water from a supplier to pass on those charges to the tenant. The reason is because when tenants are paying for water in those circumstances, it conserves water because the tenants are not wasting it. Now, this is clear from the plain language of the statute, which simply says a landlord may charge for the cost of providing water pursuant to 62-110G. Now, the language may makes clear that this is a permissive action. It's an incentive. It is in no way restrictive. And looking to 62-110G, all that statutory scheme does, it's enabling legislation that says Public Utilities Commission adopt these certain rules to govern this very specific situation where you have a provider, as the Public Utilities Commission defines. Provider is just a landlord who is passing on costs.
Would that only apply if the source of the water was public
That's exactly right.
and not from a well?
That's exactly right, Your Honor.
Was that argument raised before the district court?
Whether
That the fact that it's a private well and the source of the water is not from a public entity?
yes, that was argued at district court, yes.
Okay.
So 62-110G, the only reason it exists is to encourage those landlords who are buying water from a water supplier to pass on that water to the tenant, because that's how water is conserved. And this is what Senator Clodfelter explained on the Senate floor, and this is in the landlord's memorandum of additional authority. There's a transcript laying out his explanation of why 42-42.1 and 62-110G-A, for that matter, why they exist. And he explains that prior to December of 2003, the EPA had what North Carolinians saw as an absurd interpretation of the federal Safe Drinking Water Act. That interpretation was those landlords of these large apartment buildings, this is why the language in the session law says contiguous units, those landlords of these large contiguous buildings, multi-family units, the interpretation of the EPA was that if you're simply passing on these costs, buying water from a public utility and passing it on, sub-metering it, then that makes that landlord a public utility under this federal Safe Drinking Water Act. Now, this created a pretty significant problem in North Carolina because landlords just weren't charging their tenants for water. And that meant that tenants were leaving faucets running, leaving tubs running, wasting water. And so for 8 years, the North Carolina government led the charge in trying to change the EPA's stance. And Finally, in December of 2003, and this memo is also in the Memo of Additional Authority, the EPA finally changed its stance and said, okay, if you're merely passing on those costs, you're not a public utility regulated federally. So at the very next session of the General Assembly, North Carolina changed its laws to recognize that it for 8 years tried to change. And that's where 42-42.1 comes from. The purpose is to incentivize charging tenants. It is not restrictive in any way, and it says absolutely nothing about a private well water agreement. So that is just one independent reason for why this court should reverse on the legal entitlement element. Now, regarding the second element, which is the incidental fee element, even if the NCDCA applies broadly, there could not have been a violation because subsection 75-55(2) does not apply specifically. It only applies to the collection or attempted collection of incidental fees. And as the North Carolina Supreme Court has explained, a fee or incidental means dependent upon something else as primary. So that's the plain language of the statute shows that there's only an incidental fee if it depends upon the collection of a debt in the first place. This is clear both from the examples provided in the statute itself, which has filing fees, service of process fees, charges for court costs, and all the examples from the case law. In the Friday case and the Williams case, we have late fees and administrative debt collection fees. What all of these fees have in common, why they're incidental, is because they depend upon the affirmative solicitation and collection of a debt in the first place. It's what the debt collector charges for the trouble of having to go after the defaulted payment in the first place. Now, the water payments in this case are entirely distinguishable from all of those fees. They are not incidental to any principal debt. They stand alone. All they are is consideration for the service of providing well water to the premises. They are not incidental fees. There could not have thus been a violation of 75-55(2). Also, to the fourth element, there could not have been a violation because there was no unfair deceptive act, and there was certainly no unconscionable act. Now, for an act to be deceptive, it must have the tendency or capacity to mislead. For an act to be unfair, it must be unethical, unscrupulous, or immoral. The only allegation from the tenant of any wrongdoing in this case is the mere fact that the water payments were flat instead of metered. Now, there's nothing unscrupulous, immoral, or unethical about a simple flat fee payment. In fact, public utilities are even allowed to charge flat fee payments, as is seen in 62-110G 1B. Just one example, there's nothing nefarious about a flat fee. Since that's the only allegation of wrongdoing, there is no unfair act there, and there's certainly no unconscionable act there. So yet another reason of why this court should reverse. Now, the final reason as to issue one is that there was never any proximate cause to any injury. As we just discussed, the only allegation of any wrongdoing is that there was a flat fee. But there's no evidence anywhere in the record, and there's no finding of fact that if the fee would have been metered, that the tenant would have paid any less amount. Thus, there was no injury. The tenant got the benefit of his bargain. He paid the flat fee, and he received the water. To hold otherwise would be unjust. It would say that landlords have to provide free water to tenants, which is just simply not the law. So thus, there's 5 independent reasons for why this court should reverse as to issue one.
Under the statute 42, isn't the provision of potable water or the absence of the provision of potable water one of the conditions that the landlord is under duty to repair?
Yes, and that happened in this case.
And so if they're under a duty to repair it, to repair it and provide it, the absence of that would be a violation.
Sure.
Under Chapter 42.
Right, but the only reason there's that duty is because the tenant's paying for it.
Well, let's just say the situation where there was a well and a pump that was just included with the rental and no separate fee was charged, and the well went down. Wouldn't the landlord at that point be required under habitability to get the well up and going again?
Yes, and that's just not the case we had here. The agreement with regard to the base rent was explicit that water utility was the responsibility of the tenant. So the only consideration for that portion of 42-42 was the payment of $125 a month. Now, the parties are free to contract to alter 42-42, for instance. They can state that, yes, well water is included, and then the duty to have potable water is included in that, but there must be consideration for it. That's what 42-.
My first question to you was, can a landlord rent a house without water? under the Residential Rental Agreements Act?
That's an interesting question. That would be an issue of first impression. I don't know that the court does not need to decide that issue, but it does raise the question of, let's say there's a cabin out in the mountains that just doesn't have water. Is it then completely illegal to ever charge to rent there? That seems absurd, but it is an open question due to the duty of potability. It's just not really relevant here because the water was potable here, as the trial court found, and the consideration for that duty was the $125 flat fee payments.
So I can imagine a house that wouldn't have a stove or a refrigerator or air conditioning.
Yeah. Well, one example that actually is helpful is the Mendenhall case, which is cited by the tenants in their memo of additional authority. In that case, the tenant moved in 2 months late because the hot water heater was not working. And the court said, well, there's not just a standing obligation to have hot water, but the parties can contract. And so if there's a promise to provide hot water, then yes, there's a duty to make sure all the pipes work, right? So that shows that it's actually the contract, it's the freedom of contract between the parties that controls the applicability of 42-42. In that case, there was a promise to provide hot water, so then there was a duty to provide it. Similar here.
Okay, you got about 30 seconds left before you invade
Yes,
the rebuttal.
thank you, Your Honor. Just very briefly as to issue 2, this court should also reverse that there must be a false statement that had the capacity or the tendency to mislead. And as we briefly discussed, the allegation in the complaint that the rent was $1,350 was accurate. There's no record evidence contradicting it. The tenant on transcript page 41 testified that the amount was $1,350, the flat fee, and the tenant agreed. That's on record page 10 in the answer. The tenant agreed it was $1,350, and there's absolutely no evidence that there was any tendency or capacity to mislead. And unless there's any further questions from your honors, I'll sit down and return on rebuttal.
Okay. We'll reserve the remainder of your time for rebuttal. Argument from the appellee. Good afternoon.
Good afternoon, Your Honor. Isaac Sturgill with Legal Aid of North Carolina. I'm joined by my co-counsel, Shamika Jameson. Mr. Dunston is also present today.
So you're Mr. Sturgill?
Yes, Your Honor,
Got it.
that's correct.
Okay, thank you.
In this case, the trial court ordered Onnipauper to pay damages and civil penalties for collecting illegal fees for water in violation of our unfair debt collection statute, as opposing counsel mentioned, specifically 75-55-2, which prohibits landlords and other debt collectors from collecting or attempting to collect fees they were not legally entitled to. And the trial court properly found that these water fees, these flat fees, were illegal for 2 reasons. First, Onnipauper charged a flat fee that was not based off of actual metered usage, which violates provisions governing the sale of water by landlords, specifically 62-110G. Second, Onnipauper charged a fee for something it was already legally obligated to provide under our Residential Rental Agreements Act, which is the means or access to potable water under 42-42. And I'd like to start with the second, which is the fact that Onnipauper was not legally entitled to charge an additional fee for access to water. And I'd like to make a distinction there. It's not so much that the landlord has to provide free water, but they have to provide access to it. So in this particular case, the sole source of water on the property was the well, and what you essentially had was a situation where they signed a lease. As part of that lease, there was an implied warranty of habitability that that there would be access to potable water on the property, and then a few days later signed a lease amendment where to have access to that water, he had to start paying this additional fee. And I would like to say that there's not a question about whether or not a landlord failing to provide potable water is a breach of the implied warranty of habitability. Your Honor mentioned things like an air conditioner or an appliance. Under 42-42, there is an obligation for certain things, appliances, that if you supply them, you're required to keep them in working order. But lack of potable water, specifically under that statute, or access to that water, is considered an imminently dangerous condition under the statute. And so not having potable water means that the place is per se uninhabitable, and the landlord would have a duty, like Your Honor mentioned, to immediately repair that issue.
You agree that it's not unusual for rental premises, residential, that are connected to a public utility, for the tenant to have the responsibility to pay for the water?
I agree, Your Honor.
and sewer,
Yes.
and electricity,
Yes, Your Honor.
and gas.
Yes, Your Honor.
So the fact that a tenant pays for utilities separate from the rent, that's very common. In fact, I think that's probably the predominant model. Do you agree with that?
I do agree that it's common for tenants to pay a utility in addition to rent, but again, we're not saying that Onnipauper had a duty to provide free water in this case, but they do have a duty under Chapter 42 to provide access to water, and since the sole source of water on this property was a well, had Mr. Dunston not agreed to pay that fee, foreseeably he would not have access to potable water.
So let's say that the water was public and the main broke and you didn't have water coming to the house, but it was not his responsibility to fix it. What would happen in that case?
In that case, Your Honor, the landlord would have a responsibility to, well, I'm sorry, Your Honor, let me clarify. If the pipes on the property that is under the landlord's control, in other words, the plumbing inside the house, if something broke to where water cannot be had by the tenant, the landlord would have a duty to fix those pipes and to return access of the water to the tenant.
But my question is, if a main broke and there was no water going to the house, would that absolve the tenant of the obligation to pay rent?
Your Honor, in that case, I think that you're talking about a situation where I guess something owned by the city, like the city pipeline broke.
Right.
I think the landlord would still have an obligation to provide fit and habitable premises and potable water, which may mean finding some other type of temporary accommodation for the tenant in that situation.
There were a number of hotel bills in the record. Can you tell us what that was about?
Hotel.
For your client?
Your Honor, I am not recalling that part of the record. I'm not sure if that's something where Mr. Dunston may have had to stay in a hotel temporarily. There was another issue that's not really part of before the court today, which was an issue with the potability of the water itself. And so that may be related to that. I don't recall off the top of my head, Your Honor.
Can you explain to the court why a private landowner would have a liability under Chapter 62?
Yes, Your Honor. And opposing counsel has mentioned their main argument is that that statute is not applicable to Onnipauper because Onnipauper is not a public utility. But I do believe that's a bit of a red herring in this situation, and the reason why is because the specific section that we're talking about, 62-110G, does not regulate only public utilities. It regulates, quote, lessors of residential property as defined under 42-59, which defines leased residential premises as a house, building, mobile home, or apartment, whether publicly or privately owned, leased for residential purposes. So there are parts of Chapter 62 that apply only to public utilities, and there are other parts that apply more broadly. There are many public utilities that could also be lessors, but not all lessors are public utilities, and that statute the legislature decided in that statute to not make it apply only to public utilities, but to all lessors in general.
So is it based on the source of the water?
It's not based on the source of the water, Your Honor. There's no enumerated exception in 62-110G saying that the provision does not apply to situations where the source of the water is a well, for example, and so it applies across the board for all lessors. Another thing that opposing counsel brought up was this idea that this should only apply in multifamily contexts or in a context where the landlord owns an apartment complex, for example. He used the term contiguous units. And I would like to point out, too, as far as that issue is concerned, that there's not a carve-out in 42-42.1 or 62-110G for lessors of single-family homes. The prior version of the statute did have some language like that, but this changed with amendments to both 42-42.1 and 62-110G in 2017. If you look at our appendix on page 5, those are the annotated statutes. The first on page 5 is the annotated statute for 42-42.1. And if you can find the session law 2017-10, there's a number of different legislative history notes there, but that particular session law 2017-10 changed the application of the statute to lessors providing water to quote from the former version, which was tenants who occupy the same contiguous premises, meaning like a multifamily unit, contiguous meaning the units are touching each other, to simply lessees. So they changed it from only applying to landlords providing water to tenants in contiguous units to all landlords providing water to any lessee. So now it applies to landlords selling water to any tenants. The same session law, this is on appendix page 26, the very same session law 2017-10 changed subsection G from allowing lessors to charge for the cost of water service to persons who occupy, again, quote, the same contiguous premises, there's that same phrase, to simply persons who occupy, quote, the leased premises. So again, they remove that language of contiguous premises, which would go in line with an apartment complex, and made it apply more broadly to all lessees. And moreover, that same session law also added subsection G 4A to 62-110G, which created a process for lessors of single-family homes to apply for authority to charge water. So single-family homes specifically. So with the argument that this is only for apartment complexes or this is only for multifamily units, that may have been the case under prior versions of the law, but as of 2017, with the amendment of the statute, that is no longer the case. And again, there's no carve-out or provision in that statute for well water.
Mr. Sturgill, if the landlord is not a public utility, what does that do to your position in the case?
It doesn't change it, Your Honor, because again, 62-110G does
Is
not.
that the whole basis of the trial court's order, that he was a public utility providing water? That gives rise to the breach of warranty of inhabitability and the Fair Debt Collections practices act?
No, Your Honor. The trial court's finding is on record page 112, paragraph 61, that says the plaintiff was not entitled to collect fees for provision of unmetered well water.
Right, so let me walk you through the statutes for a minute, because you skipped over one that I think is important. It's chapter 62-3, it's the definitions section of 62. The 62 is referenced in 42-42.1. So the definitions section of 62, chapter 62, 62-3, sub 23, sub D, reads, the term public utility except as otherwise expressly provided in this chapter shall not include the following. Skip down to 4 of the subsection. Any person not otherwise a public utility who furnishes such service or commodity only to himself, his employees, his tenants, when such service or commodity is not resold or used by others.
Yeah, sure. And again, that goes to the definition of public utility, but the Onnipauper does not have to be found to be a public utility in order for 62-110G and the requirement for metered well water to apply, because that provision applies not just to public utilities, but to all lessors of residential property. And there's other parts of Chapter 62 that show that 62 can apply to things other than public utilities. So back to the definitions section that you mentioned, if you look at 62-3, subsection 2, for example, it talks about the definition of a certificate of public convenience and necessity, and it says that is defined as a certificate of public convenience and necessity issued by the commission to a person or a public utility. So that's another example of where 62 does not only govern public utilities, and again, in 62-110G, public utility is not used in that statute. The term is lessors of residential property as defined under Article 7 of Chapter 42.
Was he required to get the certificate?
Your Honor, that issue was not raised in this case. I do believe that is the case, but that was not an issue that was brought before the court.
Well, I'm trying to follow up on Judge Carpenter's argument. If the definition of who's covered under the statute excludes private property owners who are not reselling public water, how can the statute then apply to them when, by definition, they're not required to get the certificate of public necessity and that they're excluded from the definition of utility?
Well, again, the definition of public utility, granted, I understand your argument that Onnipauper would not fall under that definition, but again, under 62-110G, it is not governing public utilities, it's governing lessors of property. And as far as the certificate is considered under the definition I just read, it can be issued to a person or a public utility. So even if something's not a public utility, it can be issued to that person. And again,
That be folks that are reselling
and
utilities?
Your Honor, it doesn't only apply to, again, in 62110G, it does not mention that it only applies to situations where somebody is reselling a utility. There's no carve out for the selling of water from a well. And I think that that's only fair. I mean, I think the policy there is that regardless of the source of water, that the tenant pay for what they're actually using. Otherwise, what would stop a landlord from charging whatever fee that they wanted to? There has to be some kind of limitation on the amount for water, which is a basic, sorry, Your Honor.
Chapter 62110G, subsection 1B, appears to allow a provider to charge a flat fee, not necessarily metered. There is a provision for metering of water, but there's also a provision for the charge of a flat fee.
Yes, Your Honor, but those are very specific exclusions to the general rule that the water has to be metered, and none of those apply in this case. So, for example, in one situation, there's an exception for a landlord of contiguous units that were built before a certain date where metering water is unfeasible, but that exception, for example, does not apply. And in fact, there was a meter on this well, and to answer Your Honor's last question about whether it metered electricity or water, in the transcript, it does specify that that was a meter for water. That's under page 24, lines 21 through 22, which when asked about the meter, the property manager said it was for metering water. So it's not, those exceptions don't apply. The flat fee exceptions don't apply because this is not a case where that it fits any of those exceptions where metering the water was unfeasible. In fact, there was a meter for the water, and the landlord chose not to use it. The landlord also did not, received a warning that the fee was unacceptable. So Mr. Dunston's Alliance, which was the organization that helped pay Mr. Dunston's rent, if you look on record page 70, there was an email from Alliance to Mr. Dunston. Again, Alliance served him because he's disabled, that the water charge was unacceptable, and they asked Onnipauper to return the money to him. So it's not like Onnipauper did not have the ability to meter the water, or that they didn't have any kind of inclination that fee was unfair. Another thing I do want to address, I think it's very important, is opposing counsel's argument concerning the Brown case. This is the federal court, district court decision, which is unbinding, obviously. But I think opposing counsel is trying to read a default requirement into a debt, and otherwise someone is not a debt collector unless the debt is past due and is in default, where that doesn't exist. And so I wanted to spend a little bit of time on that case just to kind of explain why the court should not adopt the Brown decision's precedent. And so the plain definition of what a debt is under Chapter 75 does not have this default provision. So the definition is just any obligation owed or due or alleged to be owed or due from a consumer. So the Brown court, essentially, I think it misinterpreted a couple things. First of all, it overextended Friday. So Friday is a case that found that a landlord collecting past due rent and late fees could be considered a debt collector under Article 2. However, Friday did not go so as far as to say that a landlord collecting a debt that is not in default is excluded from that definition. But what the Brown court goes on to do is it references several cases from other jurisdictions. An example of that would be Austin versus Lakeview, which is a Maryland case. And it compared that to the North Carolina debt collection statute, but it essentially found that the court in North Carolina should follow those precedents from other states, but it missed a very critical distinction there. And that distinction is those cases are dealing with debt collection statutes from other jurisdictions that either mirror or incorporate the federal debt collection statute. And the important difference between the federal debt collection statute and the North Carolina debt collection statute is that the federal debt collection statute does have an enumerated express exception to the definition of debt collector that says that someone collecting a debt that is not in default is exempt from that provision. There's other differences in the definition of debt collector. For example, the Federal Debt Collection Act only applies to third-party debt collectors, so somebody that's collecting a debt that's owed to themselves is not considered a debt collector under the Federal Act, whereas they are under the North Carolina Act. And I think the Brown Court really fundamentally misunderstood that. The Brown Court went so as far as to misquote a case Reed, and what the Brown Court said is that the Federal Debt Collection Act is much broader than the State Act, which is not the case. It's actually the exact opposite of that. The Reed Court actually said that the State Act is much broader than the Federal Act for some of the reasons that we just explained. And policy-wise, that just does not make sense to me to require that a debt must be in default for someone to be considered a debt collector. I mean, that means that if any debt collector, if they charge an illegal fee or if they get somebody to agree to a fee that's illegal under the law and that person pays it on time, that somehow that debt collector is immune from liability in that situation. It's almost punishing the consumer for paying what they believe is a valid debt on time. So even policy-wise, I don't think that comports with the definition of debt or debt collector under our State Act, which is broader than the Federal Act. And
In your mind, is there a difference between an obligation to pay at a time certain and a debt past due and owed?
There's not, Your Honor. There's also a case from our Supreme Court.
Obligors and debtors are the same. We can use the terms interchangeably.
I believe, and I'd like to point you, there is a case from the Supreme Court of North Carolina that is the Blesdo case that essentially says a debt becomes a debt at the moment it's due. So if you're paying the debt on the due date.
That's the distinction I'm talking to you about. If it's not due yet, it's an obligation to pay at a time certain. When it becomes due, then it becomes a debt. It would logically follow in my mind, but that's why I'm asking the question. I want to know your thoughts on it.
I believe so. I believe at the moment it becomes due, it becomes a debt, and Mr. Dunston was paying his bills on time, and therefore he was paying debts. And I think that the Onnipauper, just by accepting those payments, was collecting them. So again, I would encourage this court not to adopt the Brown decision in this case. And I also wanted to talk about a couple other things. The issue of proximate cause, opposing counsel has argued that there has to be, you have to show proximate cause between the unfair act. Again, the unfair act in this case is under 75-55-2, which was collecting fees that Onnipauper was not legally entitled to for the reasons I just explained. There is actually a case from the North Carolina Supreme Court, I believe in 2021, the McMillan versus Blue Ridge case, that actually said that even just the attempt to collect a debt, so even if there is no actual damage, that can trigger the penalties under 75-56 under Article 2. The court used the language a statutory injury, having the debt collector simply attempting to collect the debt, and that tracks with the language of 75-52 that a landlord collecting or attempting to collect the debt is violating that statute. But in this case, so I don't believe that even if Mr. Dunston had not paid the fees on time, and if Onnipauper had tried to collect them and he refused to pay them, I think Onnipauper could still be liable for attempting to collect the debt. And under the McMillan case, actual damages would not be required because there would be a statutory damage or a statutory violation in that case. But in this case, there were actual damages because he paid the fees 29 times over the course of his tenancy. He paid this illegal flat rate for water 29 separate times.
He contracted to do that, didn't he?
He did contract to do that, Your Honor, but and we respect the freedom to contract in North Carolina, but it is not absolute. And there's a case that's cited both in opposing counsel's brief and in my own that speaks to that. And we're looking at the principle there is that if a contract provision is in violation of a relevant statute or public policy, that provision is not enforceable. That's the Hanslick case, which I believe, opposing counsel cited that as well, but.
Unenforceable and illegal are different. You've used the term illegal, and you're reading from the language of the case that says unenforceable. Those two things are different in my mind.
Well, I think that the reason it is unenforceable is because it's illegal, and there's another case, the Lamb case that we cite, that kind of makes that connection that says an illegal contract is not enforceable. So I think that the fact that it's illegal is what makes it unenforceable.
Well, it could be unenforceable because it expired. It could have been accomplished. It could have been completed. So there's a lot of reasons a contract may be unenforceable, but not necessarily illegal. If it's satisfied, if the contract's satisfied, it's unenforceable because it's been satisfied. You couldn't bring an action against a contract where all performance has been rendered. You do agree with that?
Well, I understand the distinction you're making, but I would just go back to saying the reason why this fee is both illegal and unenforceable is because it violates the public policy and both the statute 4242 and 62110G that requires the metering of water.
Let me ask you this. Let's say that the fee, since do we agree it's not based on usage?
Absolutely, Your Honor.
Okay, could a landlord not charge a flat fee for electrical service provided to run the pump and to repair the pump, and not charge for the actual usage?
Your Honor, I'd have to go back and look. I believe there's a similar, it's not part of the same statute. I believe there's a similar provision in Chapter 62 that deals with landlords charging for electrical usage, and I think that also requires it to be based on meter consumption. I believe so. Okay,
let me ask you this. Do you agree that the only way to dispossess a residential tenant in North Carolina and regain possession is through summary ejectment?
Yes, Your Honor, that's correct.
So that was the sole means that the plaintiff had to regain possession of the property. Do you agree with that?
Yes.
So if that's the sole means they've got to enforce their rights on a holdover tenant, do you agree your client was a holdover tenant?
Your Honor, he did stay past the term of the lease. There was also an issue with defective notice in that case, which is why I think the holdover claim fell, but he did hold over past
the lease had expired. Do
yes,
we agree
Your
on
Honor.
that?
Yes, in that sense, he was a holdover tenant. Your Honor.
Okay, so if the only way that the landowner could enforce their right would be to file a summary ejectment proceeding,
yes,
which is what they did, and there were monies owed, the $1,350. How could that be an illegal act to try to just enforce your rights to the only method that you have?
Your Honor, I think that the trial court's finding on that, if you give me a second, let me find that here.
How can that be an enforcement of a debt if that's the only way you've got to regain possession?
So I think that the section that the trial court looked at on the second issue, as far as the violation for what was written on the complaint that was filed, was based off of a provision. It's not that they're trying to enforce a debt or collect a debt from Mr. Dunston, but what that provision of Section 54 says is that it's illegal for a debt collector to misstate the character or the extent of a debt in a legal court filing. So it's not the fact that he was trying to collect money that he believed that was owed to him at that time. It's that he misstated what the actual rate of rent was. And the court did find, I mean, that was the court's finding there, is that the rate of rent that Onnipauper was claiming that was owed was more than what the actual rate of rent was. I think
I asked that question to counsel about the $50. It seems to be a dispute over the $50. He has said that the rent went up over the stated term, and that the $50 that he had sought to recover under the summary ejectment did not include the washer and dryer, that they all agreed that they were not going to bill because your client wasn't using it.
Your Honor, and we were trying to review the record while he was making that argument. I cannot find a place in the record where a higher rate of rent happened during the course of the tenancy. What I can see is that...
Do you agree that once a stated rent in a lease agreement expires and a tenant becomes a holdover tenant, the landlord would be free to increase the rent?
I think the landlord would be free to give the tenant an option there. I think that
I understand that they demanded that your client vacate, and your client refused.
I think that in order for the landlord to raise the rent at the end of a term, they would need the tenant's agreement. I mean, the landlord could give the tenant an ultimatum, but as with any contract, there has to be a meeting of the minds, and if the term of rent were to go up, the parties would have to agree on that. Now, the landlord could give the tenant an ultimatum and say, I want to raise your rent by $100 a month. Your lease is ending in 2 months. And if the tenant doesn't agree, then the landlord could say, well, I'm not going to renew your lease, and then proceed with an eviction case in that situation. So very quickly, in summary, in conclusion, Onnipauper violated 7552 by charging and collecting 29 illegal fees for Mr. Dunston. The 2 reasons why they were not based on meter consumption as required by 62-110G. And again, that statute does not only govern public utilities, it governs all lessors of residential properties. And also because it violated 42-42 because it required Mr. Dunston to pay a fee, not for access to water. So again, landlords do not have to pay for the water for the tenant, but they have to provide access. That's a lack of water is an eminently dangerous condition on the property. And I will just close by saying this case has a unique set of facts. I mean, I've been representing tenants for close to 10 years at this point, and it's the only case I've ever seen where a landlord signed a lease, later signed an amendment with a flat fee for well water, even though the well had a water meter on it. We're just asking that the court apply the letter of the law as written to these unique facts. Doing so will not send a tidal wave through the landlord-tenant legal world. On the other hand, if the court accepts some of the arguments that Onnipauper is presenting concerning debt collection in general, like the position that the court should rewrite the definition of debt collector in Chapter 75 to add a default requirement, that will send shockwaves not only through the landlord-tenant arena, it'll disrupt consumers all over the state in a variety of different contexts, everything from car sales to payday loans, you name it. So for these reasons, we do ask that the court reaffirm the award of damages to Mr. Dunston.
I have one question.
Yes, Your Honor.
And I pose this to your counsel on the other side. If we agree that the property owner had the right to charge the fee, does that eliminate or moot the debt collection argument or the basis for the award?
Your Honor, I believe if the court were to find that the fee were legal and that the landlord had the right to collect that, as far as the debt collection claim, that would remove one of the elements, which would be an unfair act. And in this case, we're arguing that the reason why the act is unfair is because it's unconscionable under 75-55-2, and the reason why it's unconscionable is because it's unconscionable for a debt collector to collect or attempt to collect the debt that they're not legally entitled to. But we do again believe there's 2 reasons why they're not legally entitled to that, as we've stated.
Okay, and I don't want to put words in your mouth. I believe you'd want the court to affirm the trial court's order.
Yes, Your Honor. We're asking that the court reaffirm the trial court's order.
Okay, thank you.
Thank you, Your Honor.
Thank you very much. Rebuttal? Mr. Winston?
Yes, Judge Tyson, I just want to clarify that the short answer to your question you just asked is absolutely yes. Counsel for the tenant just stated that subsection 62-110G applies to every single landlord in the state. That is plainly not the case. If I could draw the court's attention to subsection 62-110G8, I'll just read it for the court. Notwithstanding any provision of this chapter, the commission shall determine the extent to which the services shall be regulated and to the extent rates that may be charged for the services. Nothing in this subsection shall be construed to alter the rights, obligations, or remedies of persons providing water or sewer services and their customers under any other provision of law. The question is, what are those other examples? Well, it's the present case, Your Honors. It's that private well water agreement. And also to the contiguous issue that opposing counsel raised. The contiguous issue is not really relevant because 62-110G, it only regulates providers. That is, passing through, purchasing water from a supplier and passing it on to the tenants. In order for this court to reverse, it need only accept one of the 5 independent grounds for reversal. That provides this court, this correct conclusion, with significant flexibility. It could address each of the issues of first impression, or it could simply conclude that the trial court's order is not supported by its findings of fact on one of the more narrow elements like proximate cause or unfairness. However, in order for this court to affirm, as the tenant requests, it must take 3 unprecedented, extraordinary, and incorrect steps. First, it must apply the North Carolina Debt Collections Act to any contract that's related to household or personal, just by virtue of there being a contract formed. Second, it would expand the scope of 75-55-2 to apply to any related fee in any of those contracts, not just incidental fees. And third, this court would need to hold, as a matter of law, that every private well water agreement in this state that contemplates a flat fee is per se invalid. These 3 steps would expand the relevant statutory schemes far beyond what the General Assembly ever contemplated, and would incentivize litigants to bring NCDCA claims alongside every routine breach of contract claim. Such a result would have a significant chilling effect on the fundamental constitutional right to freedom of contract. Thus, this court should refuse to accept the tenant's invitation to take these 3 extraordinary steps. Instead, this court should remain committed to the rule of law, leave policymaking to the General Assembly, and reverse the trial court's order. Thank you.
Let me ask
Mr. Winstead, where is it in the record that there's an increase of rental rate?
Transcript page 41, Your Honor. Yin Zhang, who is the manager,
Page 41 of the.
page 41 of the transcript. Yes, Your Honor. She testified that the rent had increased.
$50.
No, from 1175 to 1350 on the base rent. So whatever. Don't want to do math on the spot. Whatever the difference is between those two. The base rent went from 1175 to 1350. She specifically said that the total rent, including the water, was 1475. Base rent being 1350. Yes.
Let me ask you this. When the legislature amends a statute, it's presumed that they are changing status quo. What is the purpose of the 2017 amendments?
The purpose seems to be that it also applies to single-family homes, as opposing counsel stated. It's not just contiguous units, but that doesn't matter because it still only regulates providers. So the single-family home, for instance, a house in the city here in Raleigh where the landlord owns the house, but the water is still coming from a public utility. And so that landlord would be a provider that's buying water from the public utility, keeps the utility service in the landlord's name, and then passes it on. But as Your Honor specified, typically the case is the tenant just contracts directly with the public utility.
Well, I'm trying to understand then, so does that go back to the source of the water?
Yes, exactly. The source of the water is what matters. Is the
So
source
it's the source of the water that triggers coverage or non-coverage under GS 62?
That's exactly right. If the source of the water is going to more than 15 units, then it's a public utility. So it would be a supplier in that case. If it's less, then it's not a public utility. So it is the source of the water that's determined. That's what makes the water supplier either a public utility or not.
So a private party can be a provider, can be a
Yes.
utility.
Sure, yeah, under 42-42.1 in the Residential Rental Agreements Act, it seems that the reason the General Assembly put that there is that, yes, a landlord, for instance, a private party, could be a provider, but it's also an open question is, does there need to be 15 or more units, or is it less? That's an open question that this court does not need to decide. It seems it could go either way, but the determinative issue is whether there is a provider, meaning the pass-through of the charge. Thank you, Your Honors.
Thank you. The case is submitted. We appreciate the good arguments from both sides, and if there's nothing further to come before the court, Ms. McKessie, will you please adjourn court?
All rise. Court's adjourned.
Did you drive here today? Where are you? Here, yeah, our office is just. I came up last night. Okay, good. You didn't have to drive. No. We live here. Our firm, just about 10 attorneys. We're down. We've got 2 offices, one over at Five Points and then one that's right down. Thank you so much. I really appreciate it. Safe drive. He goes back today, or? Great to meet you in person. Good argument. Thank you very much. It's great to meet all of you in person.